Yeah, that's not how this works, and this is where courts shut things down fast. Here's the plain, unsugared reality. He is wrong about the public defender being standby counsel. In Colorado, you do not get to have a public defender and run your own defense and treat the PD as backup or legal assistant. Those are mutually exclusive choices. The court gives him exactly one of these setups, represented by counsel, most likely right now. The public defender is in control of strategy. The PD decides what motions are filed. The PD speaks for him in court. Fredrickson does not address the court directly. He cannot file pro se motions on the side. This is the default once counsel is appointed. Pro se with standby counsel, rare and discretionary. This only happens if he formally waives his right to counsel, the judge conducts a Ferretta advisement, the court finds he is competent to represent himself, the judge chooses to appoint standby counsel. Even then, standby counsel does not argue for him, standby counsel does not file motions for him, standby counsel does not control the case, standby counsel may sit silently and occasionally advise. And crucially, open quote, standby counsel is not guaranteed, close quote. Tash hybrid representation, what he's describing. This is the fantasy option. Colorado courts do not allow hybrid representation, do not let defendants argue alongside counsel, do not accept pro se filings when counsel is appointed. Judges will literally say, open quote, you are either represented or you are not, close quote. Why judges hate hybrid representation? Because it creates confusion, breaks the record, encourages frivolous filings, lets defendants game delays, produces appellate messes. Courts shut this down immediately. What will happen if he tries this in court? If he says, open quote, I'll control my defense and the PD will be standby, close quote. The judge will respond with something like, open quote, that is not permitted. You may proceed with counsel or waive counsel, close quote. If he pushes, judge warns him, judge puts it on the record, judge forces a choice, no middle ground. Why this matters for his case. Right now, motion to dismiss denied, PD appointed, court has reasserted control. If he tries to override the PD, file his own motions, argue law himself, turn hearings into speeches. One of two things happens. Judge reins him in hard, or he's forced pro se, which hurts him badly. Either way, the I'm in charge posture does not help him. The quiet irony. If he actually listened to the PD, many of his arguments would be dropped, the case would shrink, the risk would go down. But his insistence on control increases risk, irritates the court, makes him look unmanageable. Judges care a lot about that. Bottom line, he cannot, open quote, have a public defender but still run the show, close quote. He must choose lawyer-led defense or pro se chaos. The court will not let him pretend otherwise. If you want, next we can predict how the judge will phrase the warning, walk through what happens if he insists anyway, or map out what the PD will likely do first in this case.